everyone, welcome back. In this video, I am going to do my very best to untangle some of the questions here I've been getting about the difference between churches and ministries. Why are they both 508c1a tax exempt status, and the protections that you do receive, what paperwork needs to be filed, rather not filed, and all of that good stuff. So it's not really just one question, because it's kind of the same question or different variants of questions around churches and ministries. Disclaimer, I am not a CPA, I am not an IRS agent, I am not a lawyer, I am a private membership association advisor with David Edwards' team, and I've spent a lot of time in the last few months really wrapping my mind around all of these different ins and outs between the private and the public domain. Consider subscribing to this channel and sharing these videos, as it's really important right now as we are taking our country and our power back. Okay, so the first thing that I want you to remember is what we're talking about here is whether it is a faith-based organization, a private health association, a ministry, or a church. We are talking about unincorporated. This took me a long time to keep remembering, is that, oh, right, the status that we are talking about is unincorporated. So that right there answers a lot of the questions. It immediately takes us into a different realm than the corporated ministries or churches or public entities. It might be fun for you to think of it this way. As one of my favorite podcasters says, these are corporations. So while people, as we're watching, are walking around zombie-like, or they've been taxed to death, the rules of the corporation are making people not live. So maybe that'll help. So we're talking about an unincorporated entity. And then the other thing is, you're probably not going to be setting up a church. Update number 1. So you might set up a church, and you might not be setting up a church. However, I want you to remember that our First Amendment right, our First Amendment freedom says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for redress of grievances. Important to the conversation here is Congress shall make no law respecting an establishment of religion or prohibiting our free speech. This means they don't get to define what we are calling a church. There's no substantive evil. Private is private. And so you may or may not have a church according to how we think church usually looks like, with these regular services and a sermon at an established time. That is part of the IRS's definition of church. And we actually probably fall under some of those definitions, and you don't have to match up, but it's just nice. You say, okay, well, falling under that, but it doesn't really matter. Now, the next part of that is, in the Bible, the word church always refers to the body of believers who have given their lives to the Lord, and not to a building in which they may be gathered from time to time. And this also falls under the consideration that if you and I are walking alone in the hills or down the street, I'm still part of the church. I am the church, and I actually really get to define that. So whether or not you are establishing a more formal church, maybe you do have a church building or not,
Congress still doesn't get to define that, and in turn, neither does the IRS.
Churches have inadvertently put themselves back into the public domain by becoming the 501c3, and that is a nonprofit even though it's tax exempt, so we're not nonprofit. Okay, so some of the links here that were sent to me, one of the questions was this article that was linked was religious nonprofits that are not churches are also required to annually file a Form 990. We don't have to file any forms with a 508c1a. Tax exempt, and I'm going to talk about this in a moment, how that just immediately says, we're not giving you our records. It's outside of your jurisdiction. So there is no Form 990, and again, because we're not a non-profit. Link this as well. This article, this document is the title is 508c1a free church versus the 501c3 state church. And I'm even going to just say that we're a 508c1a faith-based organization or ministry. Rather, these churches are, the church has a set congregation and a regular meeting time or space. So your ministry is not going to be holding services and having these set meeting times or place for these services, for sermons. Like, I went to church this morning. That's different than the ministry that you might be thinking about having, or a private health association like I have. Yes, I see clients on a regular time, but I'm not giving them services, also all the sermons, although some of them might think that. So there's that distinction as well. Okay, back to this document. The section 508 states that churches or our unincorporated ministry or faith-based organization are a mandatory exception to the section 501c13. They're all
Yay, update number 2. Let's talk about mandatory in the context of these statutes. Mandatory, adjective containing a command, preceptive, imperative, and preemptory. A mandatory provision in the statute, 508c1a, is one, the omission to follow, which renders the proceedings to which it relates void, while a directory provision is one, the observance of which is not necessary to validity of the proceeding. And that's case law Schledsang versus May. So the mandatory part of a writ is that which commands the person to do the act specified, State versus Barnell and Williams versus Sherwood. It is also said that when the provision of a statute is the essence of the thing required to be done, it is mandatory. Kavanaugh versus Fash. Otherwise, when it relates to form and manner and where an act is incident or after jurisdiction acquired, it is directory merely. Mandatory statutory provision is one which must be observed, I'm going to say it again, must be observed, as distinguished from the directory provision, which leaves it optional with department or officer to which address to obey it or not. And that is State Dworkin versus Court of Common Pleas of Cuyahoga County. So remember, we have mandatory, and next we have exception. The act of accepting or excluding from a number designated or from a description that which is accepted or separated from others in a general rule or description a person, thing, or case specified as distinct or not included, an act of accepting, omitting from mention, or leaving out of considering. And accept means not including. So really it was never there to begin with, and this was the case re Kelly's estate. In the next slide, we'll put all of this together with our conversation. Okay, so this is where stuff gets really exciting, and a little bit of history. You may have heard some of this in some of my other videos or in your own research. But when the 501c3 was created and nonprofits and religious organizations and charities were required, or they asked permission to become recognized, and then they need to do all the filing and the reporting, and part of that of course is banking. Well, then organizations or religious associations and people, faith-based people with firmly held spiritual belief systems, they were disenfranchised because they were no longer able to do banking the American way. So this statute, the 508c1a, was created so that people of different faiths and spiritual belief systems weren't disenfranchised, so that they could do banking. This is one of the reasons there's that box that's checked on the SS4 form that says for banking purposes only. And we use that with 508c1a. So it's the best we've got right now. And this is under Title 26 and 6033. Of course, I will link this. But we just talked about mandatory exceptions, right? So if you look down, you'll be able to find this with the link. But if you'll look down, and we see exceptions from filing, which also means exception from responsibility, tax responsibility. I'm going to get to that in another slide further along in the video. But here we are, mandatory exceptions. Paragraph 1, so that's above, shall not apply to churches, their integrated auxiliaries, and conventions or associations of churches, any organization other than a private foundation as defined in section 509A, described in subparagraph C. And then number 3, the exclusively religious activities of any religious order. So we could go under 1 and 3 most easily, depending on how you have your private association, your ministerial association, your faith-based association set up. But this is our mandatory exception, and we're not mixing any public and private laws and public and private statutes here. We are staying solid and strong in our religious liberty, our freedoms, our private is private, and able to do banking or complete banking as an American association.
Without notifying or applying to the government under that section 501c3. When you get your EIN number for your bank, we are telling them, we're just saying, I just removed myself. There is no writing a letter, and there's a little bit more on that here at the end. We do not have to lose our voice in this. So section 508, special rules with respect to section 501c3 organizations, and we have the mandatory exception. Third page, again, I'll link this. According to IRS publication 557, tax exempt status.
And another update. So it turns out that I spent a little time on the phone with the IRS, in particular in the nonprofit department. So this is a transcript of the conversation. I'm going to paraphrase a bit and not just read this all to you. So, but I said, for context, I'm looking at the website, and at 26 USC 6033 returns by exempt organizations. I want to be clear about our understanding of exempt organizations and mandatory exceptions. So, my first question, when an organization or association is accepted from filing, does accept from filing mean the same thing as accepted from liability, meaning tax liability? She says if your organization is operating or has approved application, you could be accepted from having to submit your annual return. If you don't meet the exception, then you're required to submit those annual return, or it can be revoked. And then I say, right. It lists under 6033 the organizations that are required to file, and then we have the mandatory exceptions from filing, churches, discretionary exceptions, and certain organizations. She wants to ask about my EIN. I tell her I'm doing some research, and we're just wanting to be really clear if we're accepted from both filing and tax responsibility. They're getting EIN numbers under tax code 508 C1A, which in our understanding is created for religious organizations and associations for banking purposes only. She asks, are they churches? And I say, yeah, they're churches, ministries, faith-based organizations. And she says, for churches, this is under 501c3. That's what they're referring to. And that's those exceptions. When we say churches, we're talking about 501c3 type organizations. Are they operating under 501 or under this 508? See, she doesn't really know. And I say, yep, they're under 508. The understanding is that churches have always been allowed to have mandatory exception. A lot of them choose to go ahead and do the exemption under 501c3. Then in 1969, the government had to create a statute for people that said, no, I don't want to do the 501c3. I don't want to become beholden to the state. I don't want to register with the state, but I still enjoy this mandatory exception. So they had to create tax code 508c1a so that these religious organizations weren't disenfranchised, so that they can do banking. And she says, well, churches are required to operate under 501c3. And I say, yeah, but they don't have to. She says, well, okay, you don't have to. The information referred to in publication 557 is referring to 501c3 type church. And I say, correct. And we're back to the difference between exemption and exception and filing and liability. Let's say church or other religious entity, because Congress shall make no law regarding religious, say they're using that code for banking purposes only, and they have not submitted an application to become a 501c3 church. Do they have a tax liability because they're mandatory accepted? Sorry, you guys. She says she can't speak about 508c1a because that's not a topic she can discuss. She can talk about 501c3 because that's the one they're showing. They're required, a church is required to be under. We have the information for 501c3. We have no one trained on the topic of 508c1a because they think the churches are required to be 501c3. And I said, so basically, it's just because you have it under a mandatory exception that the code was created for banking purposes only, so that these churches weren't disenfranchised, or these religious people weren't disenfranchised and still could do business the American way, and you don't have any training on it. Is that right? She doesn't really answer my question, but she says, I'm saying if you're looking at publication 557 exception, it's referring to a 501c3 type church. Period. Done. End of story. Publication 557 is only for 501c3 type churches.
For your organization. Churches, faith-based organization. Although a church is integrated auxiliaries or a convention or association is not required to file the form, this one is 1023, to be exempt from federal income tax or to receive tax deductible contributions. The organization may find it advantageous to obtain recognition of exemption. However, as shown in the examples above and the IRS code itself, a church does not have to apply or notify the government, state or federal, of its tax exempt status. We are already established as a separate creature from the state. We need to remain separated from the state and not join in any type of partnership that would create a yoke between your religious or your faith-based organization and government, no matter what benefits they may mislead us to believe are available. Okay, we'll see you in the next video. Thanks